A very good afternoon to all my dear students. Good afternoon, Prabhat, Muskan, Vindhya, Pravinder, Shivansh, Ravi, all those who have joined the class. Mohit, good afternoon, students. So I hope you have revised what we have done in the previous class. That was yesterday. Good afternoon, Arjun. And I hope there are no doubts, but if still you have doubts, you can ask me because children, today we are going to start with Unit 3. That is another very important unit of Partnership Act. So first we will be completing the doubts from Unit 2 as well as 2 topics which were left in Unit 2. And then we will be proceeding towards Unit 3. Ma'am, can you please explain example 5 on page 4.34? All right, we will take that. Let me just quickly, yes, Arjun, you want to say something?
Yes, ma'am. Ma'am, is there Megha, ma'am?
Ma'am will speak to you today in a while, okay?
Okay, ma'am.
All right. Yes, Kunal, you want to ask something?
गुड आफ्टरनून मैम.
Good afternoon.
मैम मुझे जनवरी 2025 के एक क्वेश्चन मैं कर रहा था पार्टनरशिप का. सजेस्टेड आंसर है उसमें क्वेश्चन 3A पार्टनरशिप का, उसमें मुझे प्रॉब्लम आ रही है मैम. प्रीवियस ईयर क्वेश्चन पेपर
January 25 का question number 3A. All right. So once we are done with the syllabus, Kunal, we will just
Yes,
go to the examination question papers and we will see to that. Okay. All right. Now let's have a quick recap of a previous session. So we have already discussed the personal profits, the relationship of partners. We were doing the liabilities. Most of you have raised the previous query regarding liabilities. So notice one point that I told you that in case of a fraud, if I am a partner, say there are 3 partners, A, B, and C. So I told you A, B, and C together constitute the firm. So whenever the liability occurs, it is the liability of the firm. Now, say, for example, a fraud was committed by Mr. A. I told you in this specific case, Mr. A will be liable. Otherwise, if we are paying the funds from the firm's accounts, A, B, and C will contribute equally or whatever is the ratio towards the firm's funds and they will be liable. Now, if you ask me if a fraud has been occurred in case of a wrongful act of a single partner, whole of the firm is liable. But if there is a fraud, then even if the firm pays whole of the amount, B and C can go and recover the money from Mr. A. So either you can say Mr. A is only liable, or you can say that other partners can recover the money from the partner who has committed a fraud. Section 29 was crystal clear to all of you. We have discussed the question also. Then minor, I hope, no doubts. From the study material that you have said, example 5, we'll just open that. But let us complete the one of the topic which was left first. So retirement of a partner. So my question to the class, if A is retiring from the partnership firm, he is liable till what date? I mean, what is required to be given if you are retiring from a partnership firm? Quickly write in the chat box. Excellent. Shivansh is the first one to give the correct answer. A public notice. Very good. Riddhi, Padula Parthi, Kunal, everyone, Sarla Devi. So this gives me a sense that everybody is active and sitting in the class attentively. So absolutely correct. If a partner is retiring, they will have to give a public notice. Otherwise, if you have not given the public notice, then you will be held liable for any acts done beyond that as well. So we have discussed admission of a partner also. So the question to the class goes is, if any partner, there are 3 partners, A, B, and C. Mr. D wants to join this firm. Can only Mr. B and C give their consent or anything else is required? If out of 3 partners, 2 partners have only consented and all the partners have not consented, is there any problem in this, or you want the dash consent, unanimous consent? Excellent. Prabhat Roy, Chaitanya. Very good, Vindhya, Tamanna. So when I close the screen, I can read your name. Sandeep, Sri Krishna. Excellent. Well done, students. So we did in section 29, unanimous consent is required. In section 30, minor ke case may be unanimous consent is required. 31 also. And in 32 also, when he is leaving, either by consent of all the partners or by the agreement. But if it is a partnership at will, you can leave by giving a notice. But the most important section that we did last is expulsion of a partner, where even majority of the partners have agreed, then also you can expel a partner provided the power existed in the contract and it has been exercised in good faith. After that, we discussed that examination question also, in which we taught you that expulsion has to be in the interest of partnership, means it has to be in good faith. How it happens in test of good faith? If it is in the interest of partnership, notice has been served and the person who is being expelled should be given an opportunity of being heard. Means आप उसे सुनवाई का मौका दोगे, ऐसे ही फॉर्म से निकाल नहीं दोगे. Then we had section 34. Two tiny sections were left in this unit. We will quickly complete them. Section 34 talks about insolvency of a partner. So when a partner is considered to be insolvent, an order of adjudication is made. Now, it is not necessary whether the firm is dissolved or not. Today, when we start with the topic of dissolution, I'll tell you what are the cases in which dissolution happens. But if a partner is being considered insolvent, what was the meaning of insolvent? That means a firm or a partner does not have sufficient assets in order to pay the liabilities. Now, if a partner is adjudged insolvent, then it is not necessary the firm may be dissolved. Where the firm has not been dissolved, then the estate of the insolvent partner is not liable for any actions done after his insolvency. So you have now left the firm, you have been declared insolvent and you have left the firm. But the remaining partners still continue with the other partners, they still continue the business. Can you hold the insolvent partner liable for the firm's actions? Law says no. Insolvent partner is liable only till the date of insolvency. Very good. Everybody has answered also no. That's correct. So let's once open the study material and read it from there also. All right. First, I'll open 4.54 page where you have raised the query. इंसॉल्वेंसी में भी पब्लिक नोटिस देना पड़ता है. नो बेटा, इन केस ऑफ इंसॉल्वेंसी एंड डोरमेंट पार्टनर पब्लिक नोटिस इज नॉट रिक्वायर्ड. ऑलराइट, so page number 4.54. Which example, Padula Parthi, can you just write your query once again? Which example you wanted us to take? Meanwhile, let's see these points of insolvency. So in insolvency, you simply have to learn this chart. See, module has so beautifully elaborated the things. This is what Act Section 34 says. And then they have made this beautiful flow chart for you that you can simply read from here. The insolvent partner will not continue as a partner, number 1 point. Number 2, from the very date जब court ने order pass करा that he has been declared insolvent, from that date he will be insolvent, means he will not be a partner anymore. Point number 3, estate of the insolvent partner is not liable for any actions after the order of adjudication. Means once the order has been passed, estate का मतलब क्या होता है बेटा? Property. अब आप उस insolvent partner की property यूज नहीं कर सकते फॉर्म की लायबिलिटीज के. एंड द फर्म इज ऑल्सो नॉट लायबल. इंसॉल्वेंट पार्टनर अभी भी कोई काम करता जा रहा है तो फर्म भी उसके एक्शंस के लिए लायबल नहीं है. वंस यूर एन इंसॉल्वेंट, नीदर योर एस्टेट इज लायबल, नीदर फर्म इज. सो ऑर्डिनरली इंसॉल्वेंट रिजल्ट्स इन डिसोल्यूशन. वो कहते हैं एक बार आप इंसॉल्वेंट हो गए हो तो देखने में अपेरेंटली यही लग रहा है कि आप फर्म को डिसॉल्व कर देना चाहिए. But if the partners continue to agree, then they can still continue without giving the orders of dissolution. All right. So I think ma'am is also here. So good afternoon, ma'am.
Good afternoon, Haleen. I want to take some queries because I have receiving so many queries on a daily basis. So I want to take 10 to 15 minutes if you allow me.
Yes, ma'am, definitely. And in fact, Arjun was specifically asking for you that I want to speak to ma'am.
Yes, I received his query also.
Yeah. Yes, ma'am, please, you can.
Okay. Yes, good afternoon, dear students. Welcome in this session for paper 2 business law. We are doing unit 3 of the chapter 4, that is the Indian Partnership Act 1932, and by Wednesday we will complete this unit. Right now we are completing unit 2, but we will very soon will start unit 3 as well, and we'll finish the unit 3 on Wednesday. After that, on Friday, Sudeep sir will take the LLP class, and then later on the Companies Act and negotiable instruments we will take. So as of now, your 70% syllabus is going to complete. Okay, by Wednesday your 70% syllabus will be completed. So I am assuming that I have told many times that read the study material thoroughly. So I am assuming that still till date you have completed unit 2 from the study material. As our faculty Harleen Kaur and Sudeep sir also take the notes, also take the study material they discuss the study material in the class. So as of now, just write me in the chat box how many chapters you have completed and on which chapter you are still struck, or how many students, one by one you can write me in the chat box. So till now, till which chapter you have completed from the study material. Okay, so I can analyze your position. Yes, I am until to SOGA. What about the IPA beta? Just okay, if you have completed the SOGA, I am until to SOGA. Okay, so just try to start partnership as well. It will very small chapters is there, so try to complete SOGA and after that start the partnership act as well, because your examination is on 18 September. Law paper is on 18 September. So if you analyze the number of days, you will find that there are around 50 days left for your examination. Okay, so in this you have to complete the study material, you have to revise the study material, and simultaneously you have to do the saransh as well and do the practice also. Yes, Chaitanya is writing chapter 4. Very good, Chaitanya. Rachna, chapter 1, 2, 3 and LLP. Very good. She has completed the LLP as well. Yes, LLP is very simple. So you can read it. Akshit is writing, ma'am, I have revised SOGA, but my Indian Contract Act agency enrollment is left. Koi baat nahi beta. Akshit, if some topic is left, just start the topic which is going in LVC. Just read the Indian Partnership as well and the remaining topic as well. Both the chapters you have to complete. Otherwise, if you will complete the Indian Contract Act and you will not start Indian Partnership Act, then it will be a problem for you. You will not be able to ask your queries in live classes. Okay, so just try to finish the Indian Partnership as well. Sogami also, Tanu Shri Singh, Padula Parthi, Indian Contract Act is pending, ma'am. Anupama, you are constantly sending queries to me. Yes, you are doing a great effort, but I think your speed is low. You have to increase your speed, beta. You have to increase your pace. Okay? Then only you can able to complete the syllabus. Tamanna, last 3 units of chapter 2. Tamanna is also in Indian Contract Act, beta. This is not the correct flow. You have to speed up, all of you. Mohit is writing, I am completed chapter 1, 2, 3, company begin part. I think you have started Companies Act, but what about the partnership? You have also start Indian Partnership Act. Suhasini started the LLP. What about other chapters? Akshit is writing, ma'am, provide doubt clearing for Sale of Goods Act. Akshit, we have conducting one webinar for Sales of Goods Act. Okay, we will very soon share the flyer for the same, so you can ask your doubts in that. Okay, it will be from 4th August to 10th August. We have a webinar for all the chapters, so you can ask your specific doubts. Yes. One query I received on my Ask Your Query. Yes, very good response, but many students are left behind the syllabus. So dear students, just try to complete all the chapters till partnership, because time is very left. Just complete, because we have to revise also. Okay, once you will complete the study material, then you have to revise the study material minimum 2-3 times, because our study material is the base. You cannot skip the study material. Till 3rd August, your entire chapters will be undertaken in LVC, and from 4th August, we are conducting webinars, 6 webinars for this subject, ending 10th August, Sunday. So we have a time till 3 August. After that, if you have completed all the chapters of the study material, only then you can take the advantage of the webinars. Only then you will be able to ask your query, okay, in the webinars. Then one query, common query I am receiving on eSahayata or your Ask Your Query mobile app, that ma'am, how to present the answers. Beta, this I have taken so many times that ये एग्जाम के लिए कहाँ रजिस्ट्रेशन करना होगा? एग्जाम के लिए बेटा एग्जामिनेशन में जाना पड़ेगा आपको, एग्जामिनेशन पोर्टल में. आई थिंक एग्जामिनेशन फॉर्म की भी लास्ट डेट थी. आई एम नॉट अवेयर अबाउट द एग्जामिनेशन फॉर्म, but yes. So how to present the answers in the law paper? This is the very, very, very common question. Beta, you all must know that your paper is question is of 2 types. First is direct theoretical nature, and second is application oriented. Okay. Yes, so many answers I am receiving that Indian contract except unit 8 and 9. Soga is done. Previous unit with partnership. Very good. All the students are very active. Now listen to me carefully. Okay. I will ask the questions now. New question. Presentation of answer. One type of question is your theoretical, and second is application. Abhi Arjun Majumdar is also asking me a question regarding presentation of case study based. First, I will discuss the presentation of application oriented case study based. Then I will discuss the theoretical portion also, because if you analyze your paper, you will find that your 70% portion is theoretical. How to memorize, how to write the provisions. Okay. Nowadays, some students are telling, ma'am, we are able to complete the case study based question, but we are not able to write the answers in theoretical. Now it's a reverse position. Previously, the students were telling कि मैम एप्लीकेशन ओरिएंटेड क्वेश्चंस नहीं हो पाता, theoretical हो जाता. But now, since we are daily practicing the questions in our LVC and students are so active, so participative, they found they are majorly focusing on application, but do not skip the theoretical portion as well. Application oriented कैसे लिखने हैं? Application oriented questions में the simple fact is given. You have to write. You have to first read the case fact कि इसमें ये कौन सा provision लगेगा. आपका immediately it should come in your mind that which provision will be applicable. Okay, so in that first you have to write the legal provision. Yes, Shri Krishna. Provision, facts of the case, conclusion. Okay, I am just repeating. I am just reiterating that you have to write the legal provision. If the question is based on associate company, so you will write that according to the provisions of section 2, clause 6 of the Companies Act 2013, this is the provision. If you have not remembered the correct section number 2 subsection 6, you can ignore it. Simply you can write according to the provisions of the Companies Act 2013, this is the provision. Okay, first you have written the legal provision ki associate 2 subsection 6 kya kehta hai, what it says, you have to write. Then just write in brief manner the facts of the case. Okay, in very brief manner, discuss the facts of the case, like A Limited is holding limited shares in this B Limited, and whatever is the case, significant influence कितना है, 20% से ज़्यादा होना चाहिए आपका. So this is the case. So you have to write the brief significant influence. Then in the last, just write the your conclusion, your analysis, that in the instant case ये case था, then A Limited is the associate company or A Limited is not the associate company of B Limited. I am taking the example. Okay, so in this manner you have to write your case study based question. Different paragraph, use different paragraphs. Okay, because law is a आपका theoretical paper, तो अगर आप एक ही monotonous में लिख दोगे तो it will be very bad impression on the examiner. So just take the breaks in the answer. Okay, and what is the from where you can practice these questions? You can practice the questions from the model test booklet. It contains 10 model test papers. Okay, so in this manner, when you attempt the model test paper, now you will understand it is in the form of examination pattern only. You will understand that which type of questions do come and in which number of marks and style of the question. It is a theoretical question and maybe some questions can be repeated or similar questions can come in your examination. Okay, so this is the advantage of practicing the questions. Okay, so this is application oriented question, case study based. Now moving to theoretical question. Theoretical में आपको simple आपको just simple line 2-3 lines दे रखी होगी कि implied authority of a partner. What do you mean by implied authority of a partner, or what do you mean by classification of capital under the Companies Act? So you have to read the question carefully, then you can answer accordingly. You have to merely write the provisions. Okay, but the provision should be correct. Your 50% portion is application oriented, 50% paper is theoretical. But in the application oriented questions, you also have to write the legal provisions. That's why this ratio of theoretical questions increased to 70%. So now the question comes, how to memorize the provision? Okay, how to memorize? Memorize करने के लिए आपको क्या करना है? Just read the study material. Okay, when you will read the study material, na, it will automatically imbibed in your head. Okay, then you will be able to write in your question paper, in your examination. Okay, first query I have taken, presentation of answer. Lot of queries I am receiving on daily basis for this, so I am assuming that now no student will repeat this query. Yes. One query I have received yesterday, how to manage time during examination. Okay, time, कैसे time करना है? You are already aware that your question paper duration is 3 hours, but you get 15 minutes reading time. You almost aware 15 minutes reading time is there. So how to utilize that 15 minutes? You will get the question paper at 1:45. Then you can, what strategy you can follow? You can divide your 15 minutes in 3 slot. First 5 minutes, second 5 minutes, third 5 minutes. In first 5 minutes, what you have to do? In first 5 minutes, you have to read the entire question paper. Okay, this 15 minutes is very crucial. You have to read the entire question paper in first 5 minutes. Then in the second 5 minutes, what you do? Just take out the question. आपको एक question paper पढ़ के पता चल जाएगा कि what type of, which question you are not able, because there is a choice of one question. So out of 6, you have to do only 5. So which question you are not going to undertake, which you are not going to take. That, yes, so that question you will analyze that, yes, I am not comfortable in question number 4. मुझे इतना question number 4 नहीं आता, ठीक है? I am not confident in question number 4. Then you can leave the question number 4 and you can attempt 1, 2, 3, 5, 6. So this is the utilization of next 5 minutes. And then फॉर द लास्ट 5 minutes में आपको क्या करना है? यू हैव टू डिसाइड द फ्लो ऑफ द क्वेश्चंस. Always start with the question in which you are 100% confident, in which you know that I know the answer correctly. Okay, like for example, if you are confident कि yes, question number 5 तो मैंने तीनों सब पार्ट्स हैं, इतना बढ़िया मुझे, I know all the answers, I am 100% confident. So just start the question number 5. Your paper you can start with any number, any question, but maintain the flow. A, B, C. 5A, 5B, 5C. Do not interchange the subparts like 5B. First kara 5A, then 5C. Just start with the 5A, 5B, 5C. Yes, Rachna, you can ask. You have raised your hand.
गुड आफ्टरनून मैम.
Good afternoon.
मैम मुझे पूछना था, जैसे आपने अभी बताया कि क्वेश्चंस को हम सेकंड 5 मिनट में हम देख सकते हैं कि हमें कौन सा क्वेश्चन नहीं आ रहा. मैम अगर ऐसा हुआ कि मेरे को कोई क्वेश्चन नहीं आ रहा बट उसमें जैसे 3 पार्ट्स होते हैं A, B एंड C, तो अगर सिर्फ एक पार्ट आ रहा हो तो मैं वो
नहीं, आपको पूरा क्वेश्चन करना है, या तो आइदर क्वेश्चन नंबर 4 और क्वेश्चन नंबर 5. यू कैन नॉट ऑप्ट फॉर अ ऑप्शनल आंसर, सब पार्ट क्वेश्चंस. ओके.
और सेक्शंस याद नहीं होते, उसके लिए क्या करूँ?
हाँ, तो सेक्शंस याद नहीं होते तो यू कैन स्किप. देयर इज नो हार्ड एंड फास्ट रूल कि आपको लिखना ही है, मैंने अभी भी बताया. ओके.
ओके, थैंक यू.
मैम एक पेन की क्वेरी थी, आई जस्ट वांटेड टू आस्क.
ब्लैक पेन.
एवरीबॉडी इज क्लियर अबाउट दैट.
सरला देवी. Sarla Devi, you please unmute.
Ma'am, good afternoon, ma'am. Ma'am, just I wanted to... Sarla here, ma'am.
Yes, tell me.
Madam, good afternoon. I just wanted to know, is there any marks allocated, for writing section and subsection of the act?
No. At the foundation level, there are no marks allocated.
Okay. There
are no separate marks for the sections and subsections. If you do not want to write, you can skip it.
Okay.
This is the clear instruction to the examination that no marks will be deducted that if the student is not answering the sections and subsections. Okay. Nikhil Khanna, please unmute. Harleen, I will take 3 minutes only. Then I will discuss all these queries in chat box. Okay.
Good afternoon, ma'am.
Yes, Nikhil.
मैम मेरा डाउट ये मैम, जैसे मैम कोई क्वेश्चन होता है कि मैम जिसका एक्सप्लेन बड़े नंबर में दिया हुआ है कि लॉन्ग मार्क्स का क्वेश्चन है, बट मैम उसके एक्सप्लेनेशन तो होता है काफी कम टाइम में खत्म हो जाता है कि जो भी हमने लिखना है वो छोटे पैराग्राफ में खत्म हो गया. तो मैम कोई कहता है कि पूरा पेज में एक आंसर लिखो, कोई कहता है कि चाहे छोटा आंसर उसको ही बड़ा. मैम कैसे लिखना चाहिए?
नहीं, आपको पता है कि आपके क्वेश्चन की क्या रिक्वायरमेंट है. अगर क्वेश्चन की रिक्वायरमेंट आपकी हाफ पेज में कंप्लीट हो गई है, बट कोई भी क्वेश्चन आपका हाफ पेज का अगर आंसर है तो वो 7 मार्क्स का ही 6 मार्क्स का नहीं आएगा. ये प्रॉपर एग्जामिनेशन डिपार्टमेंट टेक केयर करता है कि कितना आंसर लिखना है बच्चे को और कितने मार्क्स के अकॉर्डिंग उसको मार्क्स एलोकेट किए जाते हैं क्वेश्चन को. ओके. तो ये आपको डिसाइड करना है कि आपको कितना लिखना है. जो रिक्वायरमेंट होगी, अगर आपका हाफ पेज का आंसर है तो इट विल बी अराउंड 2 or 3 मार्क्स.
ओके मैम, जैसे मैम मान लीजिए 5 मार्क्स का कोई क्वेश्चन आ गया इफ है, तो मैम मिनिमम 1 पेज इज...
यस, मिनिमम 1 पेज. और अगर उसके क्वेश्चन की रिक्वायरमेंट है कि कई बार लेंथी क्वेश्चन बन जाता है, कई बार आपके क्वेश्चन में रिक्वायरमेंट ज्यादा है, तो यू हैव टू राइट मोर.
ओके, थैंक यू मैम.
ओके. प्रणव.
ओके.
गुड आफ्टरनून मैम.
गुड आफ्टरनून.
केस स्टडी क्वेश्चन में आप खुद से लिख सकते हैं बना के?
क्या बनाओगे बेटा? क्या बनाओगे? आपको लीगल प्रोविजन लिखना है ना? फैक्ट्स ऑफ द केस लिखने हैं. लीगल प्रोविजन फ्रॉम वेयर द एक्ट से लिखोगे एंड योर फैक्ट्स ऑफ द केस आपको क्वेश्चन में से अपने आप बना सकते हो. आप उसको थोड़ा सा, अगर आपको लगता है कि आप एज इट इज नहीं लिखना चाहते, तो यू कैन यूज योर प्रेजेंटेशन इन दैट. बट एनालिसिस भी आपको अपने आप ही बनाना है. बट लीगल प्रोविजन आपका अच्छा होना चाहिए. ये मैं आई एम नॉट सेइंग कि यू राइट एज पर द बुक. Okay, you cannot write as per the book, but when you read from the study material, it will automatically, you will write in legal language.
Basically, okay. Ma'am, they should not change the meaning of the law. This is what I've told them. आप अपने words में लिख दो, but don't change the meaning.
Legal terminologies you should not change. As I always take the example of small company. Paid up share capital 4 crore, turnover 40 crore. So this you cannot change. Previous financial year, these type of legal terms you should not change. Harleen, I will reply all these through chat.
Because now they all have started raising hands. So
yes, there are so many classes we are taking. 2 BUS for success will take.
Similar
so we
queries
will
are raising. Yeah.
Okay, thank you, Harleen.
Thank you for all your help for guiding the students. Let's move forward now. All right, students. So ma'am has already helped you and guided you for all your queries as usual. So let's continue with Partnership Act now. So 2 queries I have seen related to, one is example number 5 and another example number 9. So example 5, Padula Parthi wanted me to explain. So beta, here example number 5 simply tries to tell you what is within the implied authority of a partner. First, you have to see what section and what content are we talking about. When we are specifically talking about the implied authority, इसका हिंदी में भी मैंने आपको मतलब बताया था कि क्या मेरी एज अ पार्टनर मेरी जो पावर में है वो मुझे बताने की जरूरत नहीं है, मैं वो कर सकता हूँ. एंड वट एवर आई एम डूइंग विद इन माई इम्प्लाइड अथॉरिटी दैट विल ओनली बाइंड द फर्म. Is that clear? So we have to remember these points, that it must be in the usual course of business, normal conduct, doing it in the name of business, and it binds all the firm. I told you any personal activity is not mine. Similarly, X a partner in the firm of solicitors. Solicitors kind of lawyers. So he borrows money and executes a promissory note in the firm. Just read this word, without authority. मतलब उसे authority नहीं थी ये काम करने की, तो क्या partners liable हैं? You tell me in the chat box. Will the partners be liable if any partner is doing any act which is not within his authority? Will the other partners be held liable? No, they will not be held liable. So this is simply the case of implied authority, that if your partners are only held liable for the specific things that you have done in the normal course of business. Clear हो गया? अब example 9 किसी ने पूछा है, उससे पहले अभी मोहित ने section 23 लिख दिया. Mohit, section 23, बेटा आपको सिर्फ it is trying to tell you that if one partner has admitted, एक पार्टनर ने कुछ कह दिया तो मतलब मान लिया जाएगा कि सारी फर्म ने इस बात के लिए हाँ करी. अगर X ने कहा स्पेयर पार्ट इज सूटेबल, Y को नहीं पता, it is assumed under Indian partnership under section 23 that yes, Y has also agreed to this. All right, so Y has also agreed to this. This is not required to be written over. This is not required to be told by him. It is assumed. Is that clear? So here in example number 9, we are talking about the notice to one partner. So one partner, say for example, the firm has received a legal notice. Now you are running a firm and you have, there's so many restrictions mentioned. Yes, Padula Parthi, those restrictions are only for specific, those 8 categories. Those are statutory restrictions. There you cannot use that implied authority. Otherwise, if you are using any implied authority which is not covered, then also other partners are not liable. All right, thank you, Mohit. Your query is clear. Now, Kunal raised a question related to section 24. So, Kunal, I'm solving your query. So, here it is trying to tell you, say, for example, any notice received by one of the active partner, legal notice आया, Mr. A active partner है, उन्होंने receive कर. अब अगर active partner है, you remember he is entirely involved in the management and conduct of the business. So tomorrow B and C cannot say that we were not aware about this, हमें तो पता ही नहीं ऐसा notice आया. So notice to one partner means notice to all the partners. Similarly, if any fraud is being conducted, यहाँ वाले example number 9 में उसने clearly बोला है that he decided to conspire to conceal the defects. उसे पता लगा डीलर से हमें गुड्स मिल रहे हैं, वो डिफेक्टिव हैं, और उसने कहा ठीक है मैं छुपा लूंगा, बाकी पार्टनर्स को बताएंगे नहीं. आप मुझे बताइए, am I trying to do any kind of fraud if I'm concealing the defects, I'm hiding the defects, and I am in the dealership in league with the seller, I'm trying to do that. Do you think that I'm trying to do any fraud? Yes or no? Yes, ma'am. So here, how can you apply section 24? It is an exception to section 24. That is, Now only that partner will be held liable. So even if the firm pays the entire amount, they will recover it from Mr. A who has done this wrong. Clear? So now all queries related to liabilities are also done. Let's finish off this chapter. Expulsion, children, we have done this question. I hope no doubts. Insolvency, we just completed. Now, what happens in case of a death of a partner? If any partner has died, then it will not, first of all, you just mark the points that I'm telling you. If any partner dies, it says death of a partner is dissolution. But it is not necessary, subject to a contract. So number one, the death of the partner may result in dissolution, or the surviving partners can still continue if there are at least two partners. अगर दो partners हैं A और B, तो बेटा अगर एक की डेथ होगी तो फिर तो सोल प्रोप्राइटर में आ गए ना, फिर तो पार्टनरशिप रहा ही नहीं. पार्टनरशिप के लिए मिनिमम 2 people are required. So otherwise, if there are 2 people, then yes, it will come to an end. If there are more people, then yes, you can continue with the surviving partners. 2 points हो गए. Point number 3. Estate of deceased partner will not be liable for any future obligations. आप एक partner A, B, C, 3 partners है, B has died and A and C continue to do the business. Will you think B's property is liable? No, ma'am, because he has already died. So his legal representative cannot be made liable for the act's future obligations. जो बाद में कर. Suppose the partner died on 1st October 2024 and A has borrowed a loan on 1st November 25 from a bank. Can you hold B's property liable? Any activities done after 1st November, he will not be held liable. Clear to everyone? X was a partner. And another 4th point, please note down, does the partner has to give any notice? No notice is required. In case of the deceased partner, no notice is required to be given. So X was a partner and the firm ordered goods in X's lifetime. But the delivery was made after X's death. X has already died and after his death, the delivery of goods was made. Now, can you hold him liable? He will not be liable because a creditor has only a personal decree. बेटा personal decree का मतलब होता है case file करने की capacity. मतलब आप किसके against case file कर सकते हो? Only against the surviving partner. Okay, so even there was no liability of the representatives of the deceased partner. Padula Bharti is asking if the deceased partner's legal representative want to continue, then yes, you can join in hands and continue in the partnership. So I hope all the sections 32, 33, 34, 35, 36 are 35 are clear to you. They are relating to outgoing partners in which we have discussed about retirement, insolvency, death, and expulsion of a partner. Now let's see section 36. Now this is a very important section which reminds me of Indian Contract Act, section 27 of the Indian Contract Act. All of you remember section 27, children? Agreement in restraint of trade. If you are a partner in the firm and you're leaving the firm, outgoing means आप firm को छोड़कर जा रहे हैं. So you will not use the firm's name. You will not represent carrying on the business. You will not solicit the customers of the firm. Solicit means to attract. Now you were a partner in my firm, Mr. A, B and C were partners and A is leaving the firm and going back. So A cannot, within the specified period and specified local limits, cannot use the firm's name, cannot do the similar kind of business, and also cannot attract my customers because A is already aware about what the customers in my business, and now he's trying to take my customers. He is doing the competing business under section 35 and section 27 of Indian Contract Act. That is not allowed. Section 36 of Partnership Act, and also there is a restraint under section 27. So I was just listening to your queries. You were asking sections are compulsory. So children, we keep telling you sections are not compulsory. Neither any marks are going to be deducted. But if you write a wrong section, it gives a very wrong impression. Never write a wrong section. Better to write as per the provisions of the so-and-so Act. Now, rights of the outgoing partner to share the subsequent profits. Now, if you are an outgoing partner, you are leaving the firm and the final settlement has not been done, keep marking these points, keep using highlighter and highlight all these points. Final settlement नहीं हुआ है and आप firm छोड़कर जा रहे हैं. Then, without any final settlement, the firm, you are leaving the firm, and then his estate will not be liable from the date when he ceased to be a partner. And if you are earning profits at the rate of 6% per annum, if his property has not been given, final settlement has not been done, then he will charge a rate at the rate of 6% per annum on the amount of his share in the property. So there is a right given to the continuing partners that they can continue to do the business even without doing the final settlement. Then interest has to be given to the outgoing partner at the rate of 6% per annum. Now these section 36 and 37 are very interesting and very important also, because बच्चे क्या करते हैं, implied authority अच्छे से पढ़कर चले जाते हैं, admission पढ़ लेते हैं, retirement, expulsion इसको पढ़ते ही नहीं है, सोचते हैं छोटे छोटे sections है. Examiner आपको case study दे देता है इन sections. So please, my humble request, all these tiny chapters like sale of goods, partnership, LLP, don't leave a single line. Everything is important. Okay, bacha, everything is important. And as far as your understanding, keep on learning it. Okay. So ABC are partners in the manufacture of machinery. A is entitled to 3/8 of the partnership property and profits. तो ए का कितना हिस्सा था, 3/8 ऑफ द प्रॉफिट्स उसको मिलते थे. ए बिकम्स बैंकरप्ट whereas B and C continue the business without paying A's share. अब ए इंसॉल्वेंट हो गया, बैंकरप्ट हो गया, बट उसका शेयर नहीं पे करा एंड वो बिजनेस करते जा रहे हैं. So from the date of insolvency until the liquidation, A will get the 3/8 of the profits. After this date, 6% per annum interest can also be recovered. A, B, or C are partners. C retires after selling his share. A and B fails to pay the value of share to C. Here, on the date of retirement, he has a debt from the date on which he ceased to be a partner. जिस दिन से वो फर्म छोड़कर जा रहा है, till the date his amount has not been paid, he will get his share of profits, plus he will also recover the interest. Okay, children? In both the cases, if the firm is continuing the business with your property, you are entitled to get an interest. And the last section of this unit, that is section 38. Again, I say this very important because if you'll see past question paper trends, 2 to 3 marks question has come up from this tiny small paragraph. What is this paragraph trying to tell? First of all, let's understand each and every word, meaning of the word written over here. पहले तो मुझे बताओ रेवोकेशन क्या होता है. रेवोकेशन मीन्स कैंसिलेशन, कैंसिल कर देना. कॉन्टिन्यूइंग गारंटी मीन्स जो फर्म ने किसी को गारंटी दी है कॉन्टिन्यूस. कॉन्टिन्यूइंग गारंटी कैसे होती है, जैसे फर्म ने कहा इफ यू डोंट पे आई विल गिव यू 1000. If Mr. A will not pay next month, I will give 2,000 on behalf of the firm. All this is known as continuing guarantee. Means the firm is giving the guarantee on behalf of the partners, on the behalf of the outsider, that if you will make a default, I will pay. So first time 2,000, next time 10,000, next time 3,000. So this is a continuing guarantee. All right. So here the continuing guarantee will also come to an end if the firm is changing. Okay. Any change in the firm, if it is happening, means the firm is changing its business, or the partners are coming in or going out. Then with respect to the future transactions, the continuing guarantee will also come to an end. So section 38, a continuing guarantee given to a firm or third parties. Just a second, students. Let me see the students who are writing on the portal also. Just read this paragraph. All right. So a continuing guarantee given to a firm or a third party. Either the guarantee has been, what is the meaning of guarantee? If the firm makes a default, we will pay on behalf of, or any given guarantee to a third party. If there is any change in the constitution of the firm, constitution of firm कैसे change होती है? कोई partner join कर रहा है, कोई partner leave कर रहा है, तो firm का constitution change होता है. Then this guarantee will also get cancelled in respect to the future transactions. So simply write down that, say for example, I have given you, a firm has been given a continuance guarantee for 1,000 for 1 month, next month 1,000, next month 10,000. So ऐसे करके उसने guarantee दी है कि अगर firm कोई भी default करेगा, तो Mr. A has given a guarantee or any bank has given a guarantee. Now this firm, there were 3 partners, A, B, and C. Another partner has joined D. Now this continuing guarantee for the future transactions will come to an end. This is simple thing that he's trying to explain. So quickly wear your thinking caps and answer these MCQs. In what circumstances a partner may retire? According to the express agreement, in case of a partnership at will by giving notice, with the consent of other partners, or all of the above? Absolutely correct, everyone. All of the above is the correct answer. Now, this kind of question, just trying to confuse you because all the points are being covered in each of the points. So, correct answer. A new partner can be admitted with the consent of all the partners, a special majority, simple majority, or a new partner. Absolutely correct, all the partners. Let's move to another next question. Which of the following are not, this we have already done, implied authority. A partner can be expelled if such expulsion is in good faith, majority of the partner does not agree, expelled partner is given an opportunity to start a business and competing with that of the firm, and if the compensation is paid. What is the case when the partner can be expelled? Be very careful in choosing the correct answer to this one. Absolutely, Mohit, 4th A, Shivansh, everyone, correct answer, Arjun. Very nice. First is A is the correct answer for this one. If a partner commits fraud in the conduct of business, this also we have done. This one also was done. So there are certain important questions which I'll be coming back to you on this. But before that, I want to start with the unit 3 with all of you. Good afternoon, Karthik. It's okay even if you have joined the class now. We have just completed unit 2 and now we're going to start with the new chapter, that is registration and dissolution of the firm. Now children, this unit 3 is divided into 2 halves. First half relates to registration of the firm, which we are going to complete today. And the second half talks in detail about the dissolution of the firm. This is the smallest chapter of Indian Partnership Act. But you will be surprised to know that in the previous question paper, 22 to 24 marks paper was entirely from Unit 3. So sometimes the things might seem very easy, can be there in the question paper also. So it's actually a lottery for you if you have studied this chapter very well and you get questions from that. So you should be doing all the chapters. That's why I keep repeating, children. Don't leave a single topic from any of the units that you're preparing so well. So let's start with registration of firm. So first of all, answer me, do you think it is compulsory for the firm to get itself registered? जैसे कंपनीज में आरओसी के पास रजिस्ट्रेशन कराना जरूरी होता है, कंपल्सरी होता है क्या फर्म के लिए? वेरी गुड. फर्म के लिए मैम इट्स नॉट कंपल्सरी. अक्षित वर्मा, तान्या संदीप, गुंजन, वेरी गुड. रिद्धि, तनिषा, Kunal, Sarla Devi. Yes, ma'am, for safety reasons. Okay, Sarla Devi, that was the answer for the second question that was coming up. But absolutely correct. Kausar, Ansari, everyone. So it is not compulsory to get the firm registered. But there are certain benefits which are given to the firm if it is a registered firm. So law says, Indian Partnership Act says कि आपको compulsory नहीं है कि registered कराना ही कराना है, आपको वो थप्पा लेना ही लेना. But if you are not registered, then there are 4 important consequences which we will be discussing in the class today. What happens if you are not registered? But first, we will understand what is the process of registration of the firm. Section 58 tells you, if you are going to get the firm registered, then you need to file a statement with the registrar of firms. Now, ma'am, what is the meaning of registrar of firms? So, children, every state has their own registrar of firms. Wherever you are opening a firm, you will have to go to that respective registrar of firms. Say, for example, I'm opening an office in Ludhiana. I will have to go to Punjab's registrar of firms. If I'm opening an office in Delhi, then I have to go to New Delhi registrar of firms. जिस स्टेट में आप खोल रहे हैं, उस स्टेट के ROF के पास आपको registration के लिए जाना पड़ेगा. Now, what is the requirement? What all is required to be filed with this registrar? A statement needs to be filed showing the firm's name. Firm का नाम क्या है? Place of business. कहाँ पे वो business करेगी? Name of place where the business can be carried on. Date when the partners have joined the firm. Now, why this is important? Because 3 partners are there, A, B, C. They have joined the firm on 1st November 24. But there is another partner and now they are getting themselves registered. So they will give this date, 1st November 24, we have joined the firm. B has joined the firm on 1st December 24. Now, you have to give him his date of joining the firm also, depending when you are getting the registration done. Say, for example, you have gone on the registration on 31st December. तो आपको बताना पड़ेगा इन 3 partners ने 1st November को join करा है. D has joined on 1st December. But children, if you have gone for registration on 30th November, then registrar of firm does not know that D has also joined. Then how will they come to know? You will have to take a fresh registration certificate if any partner joins. So it is important to give the date when the partners have joined the firm. Full name and address has to be given. Duration of partnership has to be given. Now, if I have given the duration that we will be doing the partnership for 10 years, then what kind of partnership it is? If I have given the duration that we are going to be the partners in the firm for 10 years, absolutely correct. Tanya, Sandeep, Kunal, everyone, it's a fixed partnership. Well done. And if I have not given any duration, there is no determination of partnership or no fixed period, then it is a partnership at will. Very nice. Yes, Arjun has written, ma'am, like in memorandum, we give all the details. Yes, it is the kind of a memorandum of a firm. In companies, we use memorandum of association. Here we have to give this statement. So section 58 tells us that a statement needs to be filed containing all these 5-6 details. Then section 59 tells you that when the registrar gets satisfied that all the provisions of 58 section have been complied, मतलब आपने statement जो file करा वो बिल्कुल ठीक है, सारी चीजें बिल्कुल ठीक चल रही हैं, तो वो एक entry record कर लेगा अपने register में, and he will file that statement. So this recording of the entry proves that now this firm is going to get registered and they will issue a certificate of registration. So what is happening under section 59? Point number 1, registrar will go through all the documents and he will see that all the provisions of 58 has been complied. If yes, he will make an entry that ABC Associates entry ho jayegi firm ki usme register mein in the registrar of firms, and he will file the statement. Point number 3, he will then issue a certificate of registration. And this is how the certificate of registration looks like. The Indian Partnership Act 1932 registration number is given, Form H, C Rule 17, a registration certificate. So आप देखेंगे हिंदी and English दोनों में लिखा होता है इस पे. It is certified that a firm by name Cargo Pack with its head office address दिया हुआ है उसका पूरा Navi Mumbai, Thane, Maharashtra has been duly registered under the Indian Partnership Act. And फिर हिंदी में दिया हुआ है असे प्रमाणित कार्य से ये सब registered हो गया. So they have written everything in Hindi also because it's an Indian document. Hindi and English both are typed on this kind of document, and date is also given from 24th February 2015. Now any partners joins after this, a fresh registration might be required for that. So when does the registration gets complete? So examiner can give you a question related to this. So beautifully you have to give these 3 steps. Section 58 में steps statement बता दो क्या क्या फाइल करना है. Section 59 का mention होना चाहिए that entry is made after being complied and certificate of registration is issued. And then section 60 is tries to tell you that when compliance has been made, recording of the statement has been done, and a certificate of registration is given. That means now the firm is registered. एक ठप्पा लग जाता है, stamp लग जाता है. It's now a registered firm. And when the firm gets registered, it gets certain benefits. So what are those benefits? Which we are going to read in a while. But first, let us see the points of registration from the module also once. Private company, what are you writing? Somebody is writing private company. We are in partnership firm, children. No mention of companies over here. So this is your registration. All these steps I have told you in briefly in the notes. Each person will also sign the statement. Very important. Signing बहुत जरूरी है. हर partner sign करेगा statement को. And please don't include these kind of names in the partnership form name like Crown, Emperor, Express, Empire. ये वाले words जो कि या फिर जो approval of central government required होते हैं वो वाले words हमने firm के नाम में नहीं include करने. क्यों नहीं इंक्लूड करने? क्योंकि इंडियन पार्टनरशिप एक्ट में प्रोहिबिटेड है. दैट्स व्हाई वी कैन नॉट यूज. सेक्शन 59 बिल्कुल सेम है. 59A1 में एक पेनल्टी दी हुई है व्हिच इज नॉट गिवन. इट सिंपली ट्राइज टू टेल यू इफ टाइम लिमिट इज नॉट गिवन ओवर हियर. सेक्शन 58(1)A में एक टाइम लिमिट दिया हुआ है दैट यू हैव टू फाइल द स्टेटमेंट विद इन दैट टाइम पीरियड. इफ इट इज नॉट फाइल्ड then 100 rupees per delay or part thereof penalty will be charged. So this is the penalty for the late registration. You have given the documents, but you have not delivered to the registrar, then a penalty will be charged. Okay, so this was the only point which I wanted to cover from here, that all these words will not be included when you're filing the documents. Any doubts still here, students? So the chapter is a little more lengthy when we go ahead and move ahead. So today we will be doing larger part of registration. Okay, Tamanna says no doubt, ma'am. So I think let's take a small break here and then we will proceed further. Meanwhile, you all will be going through the questions of Unit 2. Okay, so that if you have registration is deemed, मतलब Shri Krishna मतलब मान लिया जाएगा कि अब registration हो गई. Okay. All right. Good, Sandeep. That's great. No MCQs don't come परी MCQs एग्जाम्स में नहीं आते बट हम क्लास में प्रैक्टिस करते हैं ताकि हमारी कॉन्सेप्ट क्लियर हो जाए ठीक है बेटा सो लेट्स टेक अ स्मॉल ब्रेक हियर Yes, welcome back, students. All right. Yes, somebody has written a query. If I started a partnership and I don't have the office, I have registered my house. So will my house be treated as partnership property? Yes, Shivansh, if you have registered yourself as a partnership, if your house is something that you have started to, you have decided that you will be treating it as partnership property and agreement has been made with other partners, then yes, you will treat it as partnership property. But Section 14 exclusively tries to tell you that if you are just holding a meetings in your house and you're having a separate partnership property, then you will not call it as the partnership property. Okay. Tanisha is asking if the suit has been filed. So Section 69 will tell about this thing. What is the difference between register and registrar? Padula Parthi, I was not expecting this question from you. So register means जिस notebook में आपने entry करी है, registrar is the body with which you are getting yourself registered. So here an entry has to be made as soon as the compliance has been received. They will record an entry in the register, which is called register of firms. That is a kind of a register that you make for your law notes. You use a register. They have kept certain registers over there. In that, they will make the entry. And registrar is the body with which you have to file. Okay, beta? Consequences of non-registration. I will again come back to the queries after doing section 69. Now it says, although it is not compulsory for the firm to get itself registered, neither there is any, therefore there is a penalty. Under English law, there is a penalty for non-registration. But under Indian Partnership Act, there is no penalty, neither it is compulsory to get yourself registered. However, Section 69 tries to tell you that non-registration gives rise to number of disabilities, which we shall presently discuss. Although the registration is not compulsory, but the consequences or disabilities of non-registration will have a persuasive pressure for the registration. Means, although it is not, so you will simply write down over here, although it is not compulsory to get yourself registered under the Indian Partnership Act, write down, it is not compulsory to get yourself registered, but there are certain benefits which are given to the registered firm. Or you can say, children, there are certain disadvantages of non-registered firm. अगर फर्म रजिस्टर्ड नहीं है तो उसके क्या क्या डिसएडवांटेजेस है वो हम पढ़ने जा रहे हैं. अदर वे राउंड ये सारे बेनिफिट्स होते हैं रजिस्टर्ड फर्म. So the first consequence is no civil suit can be filed by the firm or other co-partners against the third party. So एक फर्म है जिसमें 3 पार्टनर्स हैं, ABC एसोसिएट्स में ABC 3 पार्टनर्स हैं. They have supplied the goods to Mr. D, dealer, for rupees 1 lakh. Now it is a non-registered firm. Since it is not compulsory, so they did not get themselves registered. Mr. D failed to pay this amount of 1 lakh to the firm. अब आप मुझे ब्रीच ऑफ कॉन्ट्रैक्ट से याद कराओ कि अगर आपका कोई कॉन्ट्रैक्ट फुलफिल नहीं होता, can you file a case against that person? Yes or no? Yes, ma'am, we can file. Very good. Excellent. Yes, Shivansh, all the points have to be learned in section 58. Yes, we can file a case. Very good, Prabhat. But if you are not a registered firm, then you cannot file a case against Mr. D, a dealer. Why? Because for filing a case by the firm, you will have to get yourself registered. So point number 1, firm cannot file a case against the third party unless it is a registered firm. Or the person suing have to be shown in the register of firms. I told you date of joining add करनी होती है partner की. अगर आप बाद में join कर रहे हो and आपका नाम in the register of firms, then also you cannot file a case. We have a very interesting example related to this. So आपने learn क्या करना है? ये आपने learn करना है. In other words, a registered firm can only file a case, and the person suing have their name as partners can only file a case. No other person. Otherwise, if you are not registered firm, then you cannot file a case against the third. ना ही फर्म फाइल कर सकती है, ना ही को पार्टनर्स मींस ए बी एंड सी जो पार्टनर्स हैं वो भी डी के अगेंस्ट केस नहीं फाइल कर सकते इफ इट इज नॉट अ रजिस्टर्ड फर्म. Everybody clear on the first point? First I will explain you all the points, then we will revise and then we will have the quiz. No relief to partners for set off of claims. Now what is the meaning of setting off the claims? Any action brought by the firm by a third party, neither the firm nor the partners can claim any set off. Say if I tell you that I have to pay you 100 rupees and you have to pay me 80 rupees. मैंने कहा I have to give you 100 rupees and you have to give me 80 rupees. Let's set off the claim. Netting off कर क्या निकल कर आए? I have to pay you 20 rupees. I will have to pay you 20 rupees. That is known as settling of the entries. But if you are not a registered firm, then you cannot have these kind of setting of the. This means any third party can. No, Prabhat Roy. Let us first complete this topic and then you will understand it completely. Okay. So here, a third party can also. You cannot claim your set off. If you are not a registered firm, then you cannot do these setting off of entries. If the suit is valued for more than 100, so up till 100 rupees, the setting off is allowed. But if any action is filed, say for example, an action has been filed against the firm for 1 lakh, and the firm has also filed an action against the third party for 80,000. तो वो कहते हैं ठीक है आप 20,000 हमें दे दो 1 lakh. Firm had to pay 1 lakh, so firm says okay we will just knock off the entries and we will pay you 20,000. So law says this is not allowed. You will have to pay full 1 lakh and then you will have to recover 80,000. You cannot set off the claims. Aggrieved party can also not file a case against the other parties. The parties partners can also not file a case against the other parties. So अगर झगड़ा होता है तो अनरजिस्टर्ड फॉर्म में आप एक पार्टनर के अगेंस्ट केस फाइल नहीं कर सकते. However, the third party can always file a case. Now, I ask you a question. ABC wanted to file a case against Mr. D. You said, ma'am, he cannot file. Why? Because it's an unregistered firm. तो आप केस फाइल नहीं कर सकते हो. But क्या D आपके खिलाफ केस फाइल कर सकता है? Whether you are a registered or unregistered firm, third party can always file a case against. So फिर benefit किसका हुआ? Registration. However, non-registration does not affect. So first point, third party can still file a case against you. A right of the partners to file a suit for dissolution. So third partners can also file a case for the dissolution, for the settlement of their accounts. Power of an official assignee to release the property. So if there is an insolvent partner, his property can be taken into custody by the official assignee and he can file an action. And the right to claim and set off is allowed up to ₹100. So ये तो same point है third, fourth वाला कि third party claim file कर सकते हैं. ये second वाले point की exception है. Partners dissolution के लिए case file कर सकते हैं. हाँ जी, अगर आप उनके claim नहीं दे रहे हो तो case file कर सकते हैं. All right. Yes, Arjun.
Yes, ma'am. यहाँ the right to sue or claim a set off in the value of suit does not exceed ₹100 in value. मतलब नहीं समझ आया. तो it can be more than 100
Which
na?
one? Relax. Which point are you saying?
The fourth point. This means exceptions. The fourth point.
Okay, put your hand down.
Yes.
Right to sue or claim of set off if the value of suit does not exceed 100 rupees. 100 रुपए की बात है तो आपने मुझे 100 देने हैं, मैंने आपको 80 रुपए देने हैं, 20 रुपए में बात खत्म. 100 रुपए तक ये बात चलती. आपने 120 रुपीज देने हैं, मैंने 150 रुपीज देने हैं, बात नहीं चलती. मैं आपको 120 पे करूंगी, तभी आप मुझे 150 बाद में पे करना. मींस सेटिंग ऑफ इज ओनली अलाउड अप टू ₹100, नॉट बियॉन्ड.
Okay, so it cannot be more than 100. Or that means it can be 200, 500.
Beta, it can be for more than 100. You cannot set off. You have to be a registered firm. If you're unregistered firm, then till 100 rupees it is allowed. 100 rupees tak kahan aajkal case hota hai. So it is just an exception which was given when the law was made under Indian Partnership Act.
Okay.
All right. Yes, Sri Krishna.
मैम ये जो एक्सेप्शन दिया है वो नॉन रजिस्ट्रेशन के लिए बेनिफिट्स है क्या?
Yes, absolutely.
और मैम मुझे एक और डाउट है कि थर्ड पॉइंट में वन पार्टनर कैन नॉट फाइल एक्शन अगेंस्ट अनदर पार्टनर, राइट?
थर्ड पॉइंट में
नॉन कॉन्सिक्वेंस में कॉन्सिक्वेंसेस ऑफ नॉन रजिस्ट्रेशन, थर्ड पॉइंट.
All right. So third, partners are having a fight among each other. Okay. So now they want to, A partner is doing some cheating and B wants to file a case against him. Children, you tell me, if you are not a registered firm, can you file a case against each other? Yes, ma'am, or no, ma'am? Chat box. No, ma'am. That is what third point says. But I am a partner who is leaving the firm and you are getting dissolved and you are not paying me my money. My accounts are not settled. Can I file a case even if you're not registered? Very good, Sandeep, Tanisha, Kunal, Preeti. Who else says yes? Tanya, very nice. Gunjan, good. Riddhi, Kausar, very nice. समझ आ गया सबको? सो क्या बेनिफिट्स है? रजिस्टर्ड फर्म होते हो तो आप थर्ड पार्टी के अगेंस्ट केस फाइल कर सकते हो, नहीं रजिस्टर्ड हो तो नहीं केस फाइल कर सकते, ना ही अदर पार्टनर्स कर सकते. क्या पार्टनर्स एक दूसरे के अगेंस्ट केस कर सकते हैं? अनरजिस्टर्ड हो तो नहीं कर सकते. क्या सेटलमेंट ऑफ क्लेम कर सकते हैं? हाँ जी, 100 रुपीज तक कर सकते हैं, 100 से ज्यादा नहीं कर सकते. क्या थर्ड पार्टी आपके अगेंस्ट केस फाइल कर सकती है? जी हाँ, थर्ड पार्टी इवन इफ यू आर एन अनरजिस्टर्ड फर्म आपके खिलाफ केस फाइल कर सकती है. Right to sue the proceedings initiated by the legal representatives for the account. So legal representatives भी कर सकते हैं केस फाइल अगर उनका पैसा आपने नहीं दिया. Now read example 1 and we are going to discuss this. A&M company is registered in 2017 with 3 partners. A dies. In 2019, B and C file a case against X in the name of A&M company without fresh registration. Is this suit maintainable? Point number 1. If it is a registered firm, can it file a case against the third party? The answer is yes, ma'am, because it is a registered firm. Point number 2. A, B, and C were the partners when the firm was registered. Now A is no longer there. But is the name of B and C in the register of firms? Their name is already entered. The firm is registered with their name. Can they file the case or do we need a fresh registration? The answer is yes, they can file a case because their names are already appearing in that registered. We don't have to get ourselves registered again. Okay, so here the suit is being maintained by the firm is valid and the person who is filing a case has been shown as a partner in the register of firms. Therefore, the case is filed against X is maintained. But if I tell you that in this question, B and C has taken a new partner, D, and then filed a case without fresh registration. Tell me your answers by raising your hands. Then is it valid or no? I told you, you have to include every partner's name in the register of firms. Now D has joined. Do you need a fresh registration? Yes or no? First of all, in the chat box. Yes, everyone says yes. Yes, Sandeep.
यस मैम, इसमें नीड पड़ेगी क्योंकि न्यू पार्टनर ज्वाइन होगी तो फिर रजिस्ट्रेशन करना कंपल्सरी है.
Because now D का नाम नहीं आ रहा है तो B and C cannot file a case. Very good. Yes, Shri Krishnan, anything else? Okay. Yes, ma'am, compulsory says Kunjan. That's correct. So everybody is clear. When the new partner has joined, this has to be told to the registrar who will make a record of the entry. Therefore, firm cannot sue as D, the new partner name has not been entered. It is clearly written that the person suing means the person who are filing the case. Their name should be appearing in the register as partners. Is that clear, everyone? Yes, Anupama.
गुड आफ्टरनून मैम. मैम एग्जाम्पल नंबर 1 को थोड़ा सा फिर से रिपीट कर सकती है? मेरे को
Your voice is not clear, child. Your voice is not clear. Can you just write in the chat box?
Good afternoon, ma'am.
Yes.
That time I'm using headphones so that my voice is not clear. मैम एग्जाम्पल 1 के फिर से आप एक्सप्लेन कर सकते हो क्योंकि मेरे को ना ये नेटवर्क प्रॉब्लम के कारण थोड़ा सा अप डाउन हो गया तो मेरे को डिस्ट्रैक्ट हो गई ना.
So बेटा एग्जाम्पल 1 में अगर तो ए पार्टनर नहीं रहता तो बी एंड सी का नाम तो है ही रजिस्टर ऑफ फर्म्स पे, तो फर्म कैन फाइल अ केस. ओके, बट इफ न्यू पार्टनर हैज जॉइंड द फर्म, then do you need a fresh registration? Yes, ma'am, we need a fresh registration because this partner also his name has to be entered in the register of persons. Then only the firm can file the case.
It's clear, ma'am. Thank you, ma'am.
All right, beta. Anybody else has a doubt in registration of firm? Quickly ask your doubts because I am going to take your test now. Anybody having any doubts? Raise your hands. No doubts? That's great. All right. I give you 2 minutes. Read this case study and everyone has to give their answers in the chat box. Sakshi, Avni, your answers are coming over here. Everybody will give their answers. Very nice answers coming in the portal also. Avni, Sakshi, Pratham Pandey. What if they change the location of partnership? Then also you will have to update, Pratham, you will have to update the registrar. Okay, Sakshi is writing, ma'am, वो मराठी में लिखा है, yes, in that registration certificate, that was correct. Avni has asked a question, if the deceased partner, example, if the order was placed when he was alive. So child, if that liability was incurred when that partner was there, then his estate will be liable. Satyam Dubey, Niranjan Mali, Ajay, Satyam, all those who are here in the portal, keep answering. All right, anybody who would like to raise their hands and give the answer for this one. So there was Associates, ABC partnership as a senior partners, and they inducted Mr. P, an expert for manufacturing. Mr. P was blamed for unauthorized activities, and thus the approval was taken from the partners and he was expelled. Whether the action was justified or not, and what are the factors to be kept in mind? Now, this is a clear-cut question related to expulsion of partnership. Let me see how well you have answered. So Padula Parthi has written, it is justified if it is done in good faith. But what I was expecting is that you should have written what is the meaning of good faith, which Prabhat has written very nicely. So good, Prabhat, all the points are covered. So your doubt was third party can exploit the unregistered form. Yes, obviously they can take the benefit if you're not registered, but not unnecessarily. Prabhat, they will not take. Good, Tanisha. Mohit, you have just written and you're writing a wrong section. Mohit, it is section 33, not section 35. Please, child, don't write wrong sections. So you have to write section 33. First, you will give the legal provision. अब भी मैम ने दोबारा आपको recap में समझाया है कि पहले legal provision लिखना है. First, you have to tell them that what is the meaning of expulsion of partner. The partner can be expelled by majority only if it is in the good faith. Test of good faith means it must be in the interest, served with a notice, and opportunity of being known has to be. If otherwise, it is null and void. Point number 1, action was taken by the firm to expel was justified because approval has been taken and it was to protect the interest because of the unauthorized activities. उसे notice दीजिए, हालात छोड़ सकते. Following factors, वही following factors जो आपने ऊपर legal provision में लिखे हैं, वही आप conclusion में लिख दें. So children, many a times the questions are very easy and simplified. It is just important how you write it. So please be sure to express yourself nicely. Yes, Anukumar.
Ma'am, I want to give the answer of that question.
Okay.
In my own way.
All right.
In this question, according to the provision of Indian Partnership Act 1932, the Partnership 1932, the expulsion of partner discussed in this case, and the partner is not expelled in the majority of the partner. In this, it can be in good faith, first point. Second point, it can give the interest in a partnership and the opportunity being ahead.
All right, so fine, Anu. So exactly you're speaking in the same format. You have to give the provisions and then you explain it. Okay? Yes, Nikhil, any doubt?
मैम उसका सेकंड पॉइंट एक बार एक्सप्लेन कर दीजिए.
किसका बेटा? उसी क्वेश्चन का?
यस मैम. मैम वो क्वेश्चन सेकंड मैम एक सेकंड क्वेश्चन ही क्या पूछ रहे समझ नहीं आ रहा. मैम इसका आंसर भी नहीं समझ आया. व्हाट शुड हैव फैक्टर्स?
What are the factors to be kept in mind before expelling a partner from the firm? आपको लीगल प्रोविजन समझ आ गया निखिल? इसका लीगल प्रोविजन क्या क्या था?
यस मैम.
टेस्ट ऑफ गुड फेथ करना है.
यस मैम.
गुड फेथ में 3 पॉइंट्स क्या थे? कि इट शुड बी इन द इंटरेस्ट ऑफ पार्टनरशिप. पार्टनरशिप के फायदे में होना चाहिए एक्सपेंशन, राइट? आपको नोटिस सर्व करना है एंड आपको रीजनेबल अपॉर्चुनिटी ऑफ बीइंग हर्ड देनी है पार्टनर. यही 3 है फैक्टर्स जो आपको मद्देनजर रखते हुए पार्टनर को एक्सपेल करना. वो कह रहे क्या चीजें आपने दिमाग में रखनी है एक्सपेंशन करने से पहले, यही 3 चीज। सो वही मैंने आपको बोला कि कई बार एग्जामिनर आपको इतना इजी क्वेश्चन देता है कि जो आपने प्रोविजन में लिखा है एज इट इज आपने यहाँ लिख देना है कि मेजोरिटी ऑफ द पार्टनर्स, गुड फेथ होना चाहिए, कॉन्ट्रैक्ट एग्जिस्ट करता हो, प्लस ये 3 पॉइंट्स आपको जरूरी है कि आपने नोटिस दिया या नहीं।
ओके, थैंक यू।
एंड प्लस पार्टनरशिप में कॉन्ट्रैक्ट, मैंने जब आपको ये कराया था सेक्शन 33 व्हेन वी डिड, I told you whenever you get a question related to section 33, write down all these points. Number 1, this paragraph, that he can be expelled only if these points, and these 3 points are the test of good faith. तो first part का आंसर ये है test of good faith, second part का आंसर ये है कि majority of partners हामी भरेंगे तभी होगा, good faith में हो, and contract में exist करना चाहिए, partnership deed में लिखा होना चाहिए, तभी आप expel कर सकते हो, otherwise आप expel नहीं कर सकते।
ओके मैम, मैंने एक बार आपको फर्स्ट का आंसर भेजा, मैम चेक कर दूं एक बार मैम सही है कि नहीं।
ऑलराइट, यस बेटा, आई हैव सीन ऑल द आंसर्स, दे वर करेक्ट।
ओके, थैंक यू।
ओके, नाउ वी आर गोइंग टू मूव टू अनदर इंपॉर्टेंट क्वेश्चन। Everybody is going to read this question and give me the answers. A and B are partners in Mrs. AB and Company. Firm is doing business of trading of plastic bottles. A is authorized to sell the stock of plastic bottles. It was decided that A should sell these plastic bottles at the minimum price which they have decided. And if A sells at a price less than the minimum, he should first take the permission of B. Due to sudden change in government policy, price of plastic bottles were declined. To save the loss of the firm, A sold the stock at lower price. Meanwhile, A tried to contact B and he could not do as B was on foreign trip. Afterward, B has filed a suit to recover the difference between the sale and minimum price. Raise your hands and give me the answer for this one. Take 2 minutes. Raise your hands and give me. Sri Krishnan has raised his hands. Who else? Students on the portal. Good answers. Sakshi and Abni, only 2 students are there. If you can give the answer for this one. Padula Parthi, Mohit, Sandeep have raised their hands. Okay, Padula Parthi.
Ma'am, in this case, to save the loss of the firm, A has done the transaction. So B cannot file a suit against A. And A has the right to be indemnified if any loss occurs for his. That's it, ma'am.
All right, well tried, but very close, not exact. Yes, Sri Krishna.
Ma'am, A tried to save the losses for the firm. He do what a man of ordinary prudence does. Whatever the loss incurred by A, he will not liable for that loss.
All right, so he has the right to be indemnified, right? Good. Yes, Mohit. Good, Sri Krishna. Padula Parthi, put your hands down. Yes, Mohit. Okay, yes, Sandeep.
Ma'am, according to the section 21 of the Partnership Act 1932, a partner has authority an emergency and protecting the firm and save from any loss.
So what is important is the content I told you, not the section.
Yes, ma'am. तो यहाँ पे मैम whether we can do so on the provision मैम यहाँ पे is not liable for that and
very close.
कोई loss होगी तो हम से वो.
All right. So very well tried. Let's see the answer. So children, you are jumping to section 21, but you're not even clear what concept it is. So first is, even if you don't remember, I have to write section 13 clause E for you so that you know where you have to refer to this kind of topic in the study. But you will write as per the provisions of Indian Partnership Act. Every partner has the right to be indemnified. Very well spoken by Shri Krishna, Padula Parthi, and Sandeep also said right to be indemnified is important if he has acted in the ordinary and proper conduct as well as in the performance of the act of emergency. This is covered by Sandeep section 21 that अगर emergency में कुछ आप loss protect करने के लिए कर रहे हो तो firm को आपको indemnify करना पड़ेगा. This is the legal provision. ये law में लिखा गया. फैक्ट्स ऑफ द केस क्या है? सबसे सिंपल मुझे लगता है फैक्ट्स ऑफ द केस प्लीज जरूर लिख कर आया करो एग्जाम में बिकॉज इट हेल्प्स यू स्कोर द मार्क्स इफ यू आर राइटिंग फैक्ट्स ऑफ द केस. So this is the company who is doing the business. They are partners who are authorized to sell on the condition, but not to sell at a price less than the minimum price. Permission has to be there. Due to emergency, he had to sold the goods. So on the basis of above provision and facts of the problem, ये line भी learn कर लो. Conclusion में ये लिखना ही लिखना है based on the above provisions and the facts of the case. The goods were sold by A at a lower price to save the firm from the loss. This was done as an act of emergency in the favor. Hence, he is not liable to bear the loss. So what will actually happen? The firm, other partners will also have to contribute towards this loss. And now the last question of Unit 2, which I wanted to take as a test, when the continuing guarantee can be revoked under the Indian Partnership Act 1932. Arjun, you want to give the answer to this one?
Yes, ma'am. According as per section 38 of the Indian Partnership Act, then continuing guarantee can be revoked or fully cancelled or fully stopped when it is given to a firm or to a third party in respect of the transaction of a firm in the absence of an agreement as to the revoked as to the future transactions from the date of any change in the reconstitution of the partnership firm.
Excellent, Arjun. Yes, Arshdeep, you also wanted to try. Arshdeep, you want to speak? Shri Krishna, okay.
Ma'am, revocation of continuing guarantee may occur by the death of a partner or retirement of a partner or by admission of a partner.
Very good. So this was given in your old study material, how the reconstitution happens, right?
Yes, ma'am.
Very nice. Very nice. So here is the answer for all of you. And those who are still facing a difficulty, break down in the points. A guarantee which is given, continuing guarantee given by the firm or third party for the transactions in the absence of the contract, point number 2. Point number 3 will get revoked. Point number 4 for the future transactions. Point number 5 for any change in the constitution, which is on death, retirement, and introduction of power. Is that clear? So I hope everyone is clear on these points and okay, Arjun has written, ma'am, crystal clear. So we have done largely almost all the examination question paper also from Unit 1 and Unit 2. And now we are just left to complete almost half of the Unit 3. Even if I say first 2 pages, we have started with Unit 3 also. And also we have done its MCQs. Only the dissolution part and its question answers. So partner by holding out is declared by according to the express agreement by giving a notice in writing with the consent of all of the partners or when he represents himself even when he is not a partner. Remember partner by holding out? What is the correct answer for this one? Too many MCQs I keep coming and getting for you so that you learn whatever we have revised. Very good. Padula Parthi, 1D is the correct answer. Prabhat Roy, good. Shri Krishna, example, section 27. I hope now it's clear, child. D is the correct answer. Very good. Tanisha. Kunal. All of you have given the correct answer. So question number 1, D is the correct answer when he represents himself as a partner. A, B, C and Associates is an unregistered firm. The firm cannot claim set on, set off, set on and set off, or none of the above. What is the exact provision? Very good. So question number 2, B is the correct answer. The firm cannot claim the set off. As per the accepted view, ध्यान से पढ़ना है, registration of the firm is complete when the application is filed with the registrar files the statement and makes the entry, he gives the notice of registration to all the partners, court records the statement and certifies the entry. So when is the registration process said to be complete? Question number 3, which is the correct answer? So it is taking, somebody is taking so long, it means you're opening your books and finding the answer for this one, huh? Yes, Ravi Kumar, what's the answer for this one? Riddhi, set of more than 100 is still allowed. Very good. Sandeep, Tanya, Titanya, okay, very good. So many of you have given the wrong answer. So B is the correct answer. When the registrar files the statement, he makes the entry. When did we study court records the entry? Court has nothing to do with the registration. If you give a notice of registration, not that, ROF, registration certificate of registration has to be given. Okay, and that is given only once the entry has been made, the statement has been filed, and the entry is recorded in the register of firm. Now, this is very, very simple. Registration of the firm is optional, occasional, compulsory, or none of the above. Very good, Riddhi. It's optional. Tanisha, Tanya, very good. Reconstitution of the firm takes place in case of an admission of a partner, retirement of a partner, death or expulsion of a partner, or all of the above. When is the firm said to be reconstituted? All of the above is the correct answer. Very good. A and B are partners, and the wife of A and B had a fight at the club, and B was expelled. Just on that basis. Is this expulsion justified? Just because you're having a small fight, can you expel a partner? No is the correct answer. Yes, even I don't go with that. Even if you're applying the test of faith, then it's a valid reason. Minor as a partner can be made liable to outsiders. Very good. No is the correct answer. What is the time period for the public notice to be given by minor on attaining majority? So by when does the minor has to give a public notice? 3 months, 2 months, 6 months, or none of the above? Six months of attaining majority. Good, good, good. So this makes me feel proud that you all have revised. That's why you were able to answer. So now we just left with dissolution questions and dissolution problems. So before we end the class, let's understand the meaning under section 39. What is the meaning of dissolution of partnership and dissolution of the firm? Dissolution of partnership says discontinuance of relationship between the partners. Means अब हमारे बीच में जो रिश्ता था वो completely खत्म हो रहा है. Can you see the war, that barrier that has come between the partners, and they have started blaming, pointing at each other. Just the picture made understand that now we cannot be partners anymore. अब तो फर्म को बंद करना पड़ेगा. Dissolution of partnership and dissolution of firm is different. Dissolution of partnership is somebody is coming, admission of a partner. Somebody is retiring, retirement of a partner. The partnership keeps on changing. But children, dissolution of partnership form is something which is very new for you, something which you have not studied in 11th and 12th. You have studied dissolution of partnership in your questions. When a new partner is joining, admission of a partner ABC, now to share of profits ABCD. Somebody is leaving, retiring, insolvent, death. But firm के dissolution होना means complete breakdown, खत्म. अब हमारा कोई relationship नहीं है. The partnership that existed between us has now come to an end. So when the firm is dissolved, it's discontinuance of the business. ABC were 3 partners and their relationship have ended. Whole of the firm gets dissolved. But if the partnership is changing, then maybe new partners joining or some partners retire. Firm's dissolution involved winding up of the firm. Firm को completely wind up कर देना, खत्म कर देना, assets को realize करना है and liabilities को pay करना. But यहाँ पे we make a reconstitution of revaluation of assets चलना. जब partnership dissolve होती है तो revaluation of assets होता है ना. पर जब firm dissolve हो जाती है, बंद हो जाती है, तब हम realization account बनाते हैं. क्या था बेटा realization account में? कि assets will be sold off in order to pay the liabilities. A firm may be dissolved by the order of court. Court भी order कर सकता है कि firm को बंद कर दिया जाए, dissolve कर दिया जाए, means close कर दिया जाए. यहाँ पे कोर्ट का कोई लेना देना नहीं है. आपकी पार्टनरशिप को जो डिसॉल्व करना है वो कोर्ट का कोई लेना देना नहीं है, वो आपने डिसाइड. It may involve dissolution of partnership also. It may or may not involve dissolution of. Here it is the final closure of books. Here we are not closing the books. We are just simply changing the partners. Somebody was partner earlier. Somebody is now becoming. So in dissolution of firm, there is a complete closure. It is a winding up of the firm. In dissolution of partnership, we are just changing. Partners are coming, partners are going. This kind of relationship is happening. All right. So I hope the students on the portal also, no doubts. All the correct answer given by Anmi Padir is asking in the MCQ, it is stated registration as the application prescribed form is delivered. Okay. Okay, Tanmay, we will see that question from the study material. Rini is asking, what is the meaning of winding up? Apni and Sakshi, your answers are correct. What is the meaning of winding up? Winding up means closing the business. Means अब हम firm खत्म कर रहे हैं, assets जो भी firm के उसे sell कर रहे हैं, बेच रहे हैं, liabilities को pay. Okay. Thank you, Shivansh, for writing. Ma'am, all clear, no doubts. That's great. That's wonderful. One of the students has a doubt in study material MCQ, which is again from chapter 2, I believe. Okay, thank you, Rini. I'm glad your query is solved. Okay, one of the child has a doubt in Unit 2 MCQs. We'll quickly go through and open it. Anybody else having any doubts? Thank you, Ravi Kumar. Child Tanmay, can you write which MCQ are you talking about? No doubts, everything is clear, ma'am. Thank you. Thank you, Avni. I'm glad to know that. MCQ number 3. Okay. Which of the following are not in? Okay, you're asking in chapter number 4. Chapter 3. Okay, Arjun, I think you guys are asking about Unit 3, not Unit 4. I was in the correct unit. Registration वाले में doubt आ रहा है ना आपको? Okay, let's quickly see it from the module also. MCQ 3. As per the expected view, registration is considered complete when we file the complete application is filed with the registrar. The registrar files with statement and makes the entries. He gives the notice of registration. So it's B. What do you want to say? They have given a different answer. So third is B, child. What's the problem? It's correct. Yes, Arjun. What's the doubt?
Yes, ma'am. In question number 3, as per this question, so I thought that all of the options would be correct enough, but option D has been disqualified by you and me also. And then why aren't A and C are correct? Only option B is correct.
Only option B is correct, not A and C. I will show you where it is written.
Okay, okay.
So when I taught you about registration, that's why I told you this chapter is very simple, but you cannot leave a single line. It's clearly written under section 59, children, that once you have complied with all your duties, you will record an entry in the register of firms and file the statement, and then he issues the certificate of registration. That means the registration is deemed to complete as soon as the application has been filed and the entry has been made. Recording of the entry is very, very important. You have to make an entry. So जब तक वो entry नहीं करेगा तब तक आपको registration certificate नहीं मिलेगा. Clear? I hope now this point is clear to everyone. So thank you so much, students. I hope everyone has understood now. All right. Good, Arjo. Now it's clear. That's great. Let me just quickly see all the chat box. Thank you so much. Thank you, Shri Krishna, for writing that every afternoon with you is like a morning. This really makes me feel proud of my students. Thank you so much. Okay, I cannot see any other query so far. All right. Yes, Karan, you want to ask something, Vita?
Yes, ma'am. Ma'am, question is impractical question. Ma'am, question 3 marks का है तो उसमें प्लेटफॉर्म पे केस लिखने कंपल्सरी है.
3 steps you have to write, Vita: legal provisions, facts of the case, and conclusion. You cannot simply write the conclusion and end it. Okay? All right. So please go through all these topics, and if you still have any doubts, we will take up in the next class. Till then, goodbye, and see you all on Wednesday. Thank you so much. Thank you, sir. Yes.